Welcome to this virtual program of the Litigation Academy on how to conduct a Zoom bench trial. I am Brooks McGrath. I and Professor Nikki Koukas are co-directors of the Litigation Academy. While the pandemic has disrupted much of our personal and professional lives, many people in our federal and state courts are working hard to restore normal judicial operations. This presentation explores how a court, witnesses, and counsel might conduct a bench trial using Zoom. No one can say how long judicial operations will be conducted virtually, but we hope this presentation will provide helpful and relevant guidance for the time being.
I'm Nikki Koukas. I teach law at Roger Williams University School of Law in Bristol, Rhode Island. It turns out that the Socratic method, which you may remember fondly or not so fondly from law school, doesn't hold up well online. We have to use new and more engaging, more interactive methods. And we've been having some very interesting discussions also at the law school about what does this increased use of technology do for legal practice, whether that's the efficiencies created by being able to attend a deposition online or a virtual hearing in court, or the potential for programs and tools to deliver cost-effective legal services for underserved populations. Now, it's been a long time, actually, that the ABA in the model rules has said that part of the duty of competence of a lawyer is to understand and keep up with technology. So we are trying to teach our students to hang in there, keep your spirits up, and most of all, learn how to practice law, taking advantage of the benefits of this new online environment.
My name is Stacy Nicasian. I'm the chair of the District Court's Board of Bar Admissions and Education. Part of our mission is to assist the court in developing attorney training and other programs for federal practitioners. We're so happy to partner with the Litigation Academy in this program today. It's part of the court's efforts to facilitate practitioners advancing their cases during the pandemic. And we welcome any feedback you may have for our committee as to other programming that might be useful to you during this time.
I am Nora Tyre-Wittick, the clerk of the United States District Court for the District of Rhode Island. In March 2020, the world changed as we entered a global pandemic, and the federal court, along with many other businesses and government agencies, closed its physical space and moved the entire operation to a virtual environment. We hope that this video helps you as litigators as you navigate this new way of practicing law. As you struggle with all of the questions of how to advance your cases during this time, we would like to highlight how two local attorneys have worked through some of the challenges themselves in the hopes that some of what they have learned will help you. This is Paul. During our demonstration, he will be representing the plaintiff, Roberta Quinlan. This is Caroline. She is representing the defendant, Brian Kane. Paul has convinced Ms. Quinlan that taking this case to a bench trial via Zoom will not have any negative consequences for her contract dispute case. She will still have the chance to testify and get her case before a judge, perhaps a lot sooner than if she were waiting for an in-person trial. A virtual bench trial is a trial where all or most of the parties, the judge and the court staff, are remotely accessing a courtroom in cyberspace. Zoom is the platform used by the U.S. District Court. Zoom is one of many applications used by courts to conduct virtual or remote hearings. At least 48 hours before your bench trial, you will have a final pretrial conference where you will work out all of the details with the judge and the court staff. In this virtual environment, these conferences are very important to discuss the exhibits you are going to use and how the trial is going to flow. You will want to pre-mark your exhibits with an electronic exhibit stamp and submit them electronically to the court using the naming conventions provided on the court's website. If you have a litigation assistant, please ensure they have this information and use these instructions to mark your exhibits. This will assist greatly in helping the court clerks keep accurate track of the offered and admitted exhibits at trial. Choose one location to designate as your virtual courtroom.
I've got the computer open, the webcam is functioning. My recommendation is to have no other applications running, and to make sure your computer sound notifications are turned off. Otherwise they will come across to whatever you're in. So if you've done a lot of Zoom calls, you'll notice sometimes you'll hear the pings. Those are from emails coming in. So what I've done is I've not only deactivated my notifications so that it doesn't happen. General rule of thumb, I don't need to be in any application other than Zoom, and maybe if I'm launching off Outlook, open Outlook, click the link, open the Zoom, and then I close Outlook.
So before this, and I've conducted depositions before, but I don't think I was as aware of it, and I think it's extremely important for purposes of a bench trial, is your eye contact with the witness. So positioning is really important. So I acknowledge that I need to look center so I can provide eye contact to my witness. And I think it's important even for the judge to see that and for my witness to look back at me. And I think if I'm looking to the side or if I'm looking to the left, it's very distracting for my witness. And that's why I learned there are certain details of Zoom that are very important. For example, in the gallery view, you can have it on the right or you can have it at the top. And if you have it at the right, you're looking to the right, and it's just, you don't get that focus. So that little detail of having it at the top, I thought was very important because it forced me to look straight into the camera. One of the things I recognized that may be a little bit of a challenge, but the reality is it's also true in conducting a trial in person, is oftentimes you have an outline, for example, for a direct examination or a cross-examination. And obviously you don't want to be looking at your outline the entire time. And I was trying to figure out what's the best position when I'm asking my client questions. And then for cross-examination, I think it's very important to have that eye contact because I don't want the plaintiff to feel like, because if my eyes are diverging, that it's easier for them to evade the question, because I think that's one of the challenges is how do you command presence remotely? And so that's why I think eye contact is huge, and that's why it's important to have a setup that really shows that you're looking exactly to the camera. I discovered this is the best setup for me.
Although we have witnessed attorneys logging in from home one day, from their office the next, and then maybe even their car, we don't recommend this for trial.
One is, if you don't have a dedicated office with a cable modem, you're relying on your wireless connection. So our firm has a wireless connection, which is pretty strong, and I can also connect with a hardline, and I have that able to do. And I often do that with a hardline. So one issue would be how accessible is your hardline connection? Because at home, you'd have to connect generally directly to your cable modem. You can buy devices that allow you to do it into any outlet, but you need to pay for those devices.
Designate a virtual courtroom where you know the connections work and where you have access to all of the equipment you think you'll need. You may be familiar and comfortable with Zoom, but don't assume your witnesses are. Have a plan to send the exhibits you'll be referencing ahead of trial so they can refresh their recollection and will have a ready copy in case of a technical malfunction. When you begin your questioning, however, you'll want to preserve the record and ask that if they have the exhibits, they put them away so that they cannot see them during their testimony.
Which there's a feature in Zoom, share screen, and that's how you present your exhibits. And in practicing and determining what's the best method to present and save my exhibits, I determined it's the best to just go simple. So in my desktop, I only have 3 folders. I have one folder for the exhibits in its entirety. Then I have a separate folder for direct examination, and then I have a separate folder for cross-examination. And again, I just thought it was simple because when you're using Zoom, I'm going to click on share right now. And what I am doing right now is to click on Defendant's Exhibit A. This is the document that I've determined that I want to use for my client, the defendant's direct examination. I'm going to click share, and I want to confirm that everyone who is participating in this can see the document. So can you all see what I'm sharing?
Yes, Roger, yes, I can see.
Okay. It's important, I think, to have the documents already open and on your desktop. Prior to conducting my direct examination, I thought it was important to open that folder, and then opening the document, it pops up. I don't have to double click. I don't have to click multiple things. It's right there. To show an example, I'm going to just stop share and then share again. So its option is, again, it's right there. You don't have to click into your desktop. It's right there.
I've got it set up so that when I want to share exhibits, I have all of my exhibits saved on my desktop as a folder item. That means I can share them through Zoom off a folder on my desktop. That's the easiest way to share them, I think. However, I've got some increased functionality with my iPad. I also have my exhibits shared in an application on my iPad, and I can link my iPad to my share screen through a few steps, but you can do it. And then you can play with the document. You can zoom in very easily device. But if it were to fail me for some reason, I can just go through the exhibits in my folder. Sure, so I have the exhibit I want to use on my iPad already loaded up. You can switch between your exhibits, and then you click share screen, and then you do iPad. I've set it up for a cable. Hit share. Now sharing is paused, so it's not showing this on the screen. And now I'm screen sharing, and then I can pause the share by clicking that button, and now I can switch to another exhibit. Though it changes on my screen, they shouldn't see that I'm basically switching the exhibits. And then I can zoom in, I can see this is the new exhibit. I click resume share, and now people in the gallery have gone from my previous exhibit to this new exhibit using the iPad's functionality for zooming in and marking up, pointing a witness to particular provisions, highlighting key terms. You can do this all live, and as long as you don't need this to necessarily be the marked up copy since the witness isn't marking it up, you can use it more like a demonstrative. You can scroll down. You can really have fun with it. That's your email. And I'm going to stop, and the screen will resume.
In the case that we have here, Quinlan versus Kane, an important part of this case is language that's used in written correspondence, letters, and emails. I wanted to use a feature that really highlighted specific language. There's an annotate feature. This is a feature, I think, where attorney strategy comes into play, because the question is, do I want my client, like whoever I'm asking questions, whether my client or if I'm doing a cross-examination or if I'm doing an examination of a witness, do I want them to have control over that feature? And strategically, I think, at least in this case, it's best that I, as the attorney, have control over that feature. For example, if I want to ask questions to my client, I want to highlight certain language. So this can be shown here. There's an option to be able to save that highlight, which will end up in a desktop that pops up into my computer. And so if I click save, I can, at the end of trial, go to a folder that shows the saved documents, and it will save what was highlighted. I think it's important when you're doing a direct examination or a cross-examination that you only share the screen for the necessary time required, because it's a distraction. You have to be cognizant of that. Some concerns attorneys may have is my desktop going to be shown? Is other features going to be exposed that I don't think are relevant or pertinent to this case? Or is another document, another exhibit going to pop up? No, that I don't think happens here. I think that honestly happens probably more in court, where you click into your laptop, it shows up on maybe a screen. The jurors see your desktop, they see your folders, they may see something like your iTunes, they may see personal stuff on there. That's not gonna happen in a Zoom bench trial. You're not gonna see that. You have more control of what's presented. One of the things that's very interesting about this is that once you share it, anyone who is logged into that Zoom trial, they have the ability to see it.
Consider your usual courtroom setup and how you operate at trial. Do you usually have a co-counsel or a trial assistant to consult with? How are you going to talk to that person? Some attorneys successfully use text messaging. Some set up a parallel Zoom call. Others use some other chat feature like Skype or Teams. During the trial itself, there is a virtual attorney conference room. In Zoom, it is referred to as a breakout room. This room allows for confidential communications without leaving the actual virtual courtroom. In a breakout room, you can consult with a client, with co-counsel, or with other parties in confidence. Breakout rooms are started by the courtroom deputy or clerk and are not recorded. Now you are ready for your virtual trial. Remember, court staff are always available to practice prior to your trial and will always answer any questions that you have. If you still aren't convinced, take a look at what a virtual bench trial might look like. We join our counsel mid-trial as they examine their main witnesses and conduct cross-examination in the case Quinlan versus Kane.
Welcome, everyone. We're here in the matter of Quinlan versus Kane. I'd like to ask first for counsel to identify themselves for the record.
Good afternoon, Your Honor. Paul Kasimian for the plaintiff, Roberta Quinlan.
Good afternoon, Your Honor. Caroline Murphy on behalf of the defendant, Brian Kane.
Okay, thank you both very much. All right, Mr. Kasimian, why don't you call your witness, please?
Thank you, Your Honor. We call the plaintiff, Miss Roberta Quinlan, to the stand.
All right, good morning, Ms. Quinlan. We're going to have you sworn in by the clerk. Would you please raise your right hand? The clerk will swear you in.
Yes. Thank you.
All right, thank you. All right, Mr. Kasimian, you may proceed.
Thank you. Could you please tell us your full name for the record?
My name is Roberta Quinlan.
And where do you live?
I have lived in Nita City for my entire life.
Could you please give us an overview of your educational background?
Sure. I have a Bachelor of Science and a master's degree in business administration. Both are from Nita University.
What do you do for a living?
Well, when my two children were grown and on their own, I continued my career, which began when they were in middle school. I am a business broker.
And do you get paid for this work?
Yes, I do. My payment usually comes in the form of a commission, which is a fee.
Now, how did you first get to know the defendant in this case, Mr. Brian Kane?
Oh, well, I've known Brian for about 10 years. We met in 2002 on the golf course at Rolling Greens Golf Club.
Let me show you what's been marked as Plaintiff's Exhibit 1. First, do you see something on your screen in front of you?
Yes, I do. Yes, it's a picture of Brian and me. This was taken at the beginning of last summer in the golf championship round. That was before the dispute erupted.
Let's turn your attention now to this dispute you referenced. Well, actually, before I get into that, during your time when you'd go golfing together, did you learn about his business?
Oh, yes, of course.
And throughout your relationship with Mr. Kane, would you speak to him about your business?
Oh, yes, a little bit. He was very familiar with my expertise in the electronics industry, especially since his business was an electronics business.
On June 11th, did you go golfing with Mr. Kane?
Oh, yes, I did.
Does that date mean anything to you, given this matter?
Yes, I remember that day very well. That was the day that Brian confided to me that he had finally decided to sell his corporation, Kane Electronics.
Do you remember anything else that you two discussed on that day?
Well, we discussed the fact that my area of expertise professionally was the sale of electronics businesses, discussed the fact that he wanted to get his marriage back on track, which I did.
So what happened next?
The next day, I did go to his home as we had planned for noon, and we went immediately into his home and into his study, and we began to discuss the possibilities of how a sale could happen.
Did you discuss anything else about the potential sale of his business?
Oh, we discussed the various forms the sale could take in a successful company with a promising future.
Did you ever discuss a fee for your services as a broker?
Oh, yes. Brian was very familiar with my fee scale. I did let him know that if I were successful in brokering a deal for him, my fee would be 3 to 5%, dependent upon my level of involvement and time.
What did he say?
He didn't say anything at that. We just began talking about other things.
What did you do next?
Well, I went home and I wrote a letter to Brian outlining our agreement as I understood it.
Okay, I'm going to direct your attention now to another exhibit. Just give me one moment.
Sure.
And do you see what's marked as plaintiffs and admitted into evidence as plaintiffs exhibit 2 on your screen?
Yes, I do.
All right, can you tell us what that document is?
Yes, that is the letter that I wrote and mailed to Brian on the day of our meeting. And that sets forth what I believed to be our agreement.
Now, earlier in your testimony,
Mr. Kasimian, could I just interrupt you for a minute? I just want to be clear that the first exhibit and the second exhibit, these are stipulated exhibits. So
They
there's
are.
no objection to those. So I'll make them full exhibits as part of the record. And we should just be clear as we go through as you get to each exhibit that I admit it actually into evidence, okay?
Sure.
Okay, go ahead.
Sure. So now you referenced earlier in your testimony, Ms. Quinlan, the commission on the potential sale, right?
Correct, yes.
And directing your attention to this document, do you see a reference to a discussion of the brokerage fee in this letter?
Yes, I do. In paragraph 2, it states that Kane Electronics will pay me a fee calculated at between 3 and 5% of the closing value, dependent upon my time and effort necessary on your behalf.
Did you ever receive a response from this letter telling you that the arrangement outlined within it was unacceptable?
No, I did not.
What did you do next?
I went to work on Brian's behalf, contacting someone at Nita Computer World, Cliff Fuller. Cliff Fuller is the in-house counsel for Nita Computer World. I had met him at a social event at my husband's law firm.
I'd like to show you what's been marked as Exhibit 9 for identification. Just give me one moment. Okay. And do you recognize what's been marked for identification as Exhibit 9?
Yes, I do. That is Cliff Fuller, the in-house attorney for Nita Computer World, and myself. We were at a social event at my husband's law firm.
Okay, I move to admit Exhibit 9 marked for identification as an exhibit into evidence.
Objection, irrelevant.
Mr. Kasimian, what's the relevance of this social picture?
This document, Your Honor, shows that Mr. Fuller, who ultimately acquired through Nita Computer World the defendant's business, was a social friend and was known to Ms. Quinlan before the sale.
Well, I'm going to go ahead and admit it. I'm not sure it's highly relevant, but I don't see any harm. So we'll admit it, and I'll give it the weight that it deserves.
For housekeeping purposes, Your Honor, I'll have this marked and submitted as a formal with a tag later.
That's fine. So this will be Exhibit 9, and it's full.
Do you know whether Mr. Kane sold his business to Nita Computer World?
Oh, yes, he did indeed.
And what do you know of that sale?
He received top dollar, $10 million.
And who introduced Nita Computer World to Mr. Kane?
Oh, that was me.
No further questions, Your Honor.
Okay, thank you very much. Ms. Murphy, cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Quinlan.
Good afternoon.
Brian Kane never told you that he hired you to be a broker for this transaction, correct?
He did not explicitly tell me that he hired me to be a broker, but he also did not tell me to go out and seek buyers on his behalf.
But you would agree he never said, "You're hired."
He never said I was hired. He never said, "Don't do anything for me, Roberta."
But you would agree he never said to you the words, "You're hired," or anything of that kind.
He did not say the words, "You're hired." Correct.
And in fact, you never signed an agreement with Brian Kane to be a broker for this transaction, correct?
Oh, I would have preferred to have a signed agreement when I left that day, but our meeting was cut short, but it was clear to me that we did have an agreement.
But isn't it true that you usually have a broker agreement through a broker agreement form?
I do usually have a broker agreement, yes, but I felt that a letter was more appropriate given the friendship that I shared with Brian.
Oh. Sorry, you cut off for a second. Can you repeat what you just said?
Oh, sure. Would you mind repeating the question?
Yes. You usually have a broker agreement form that you use when you form an agreement with a client to become a broker.
Yes, traditionally I do have a broker agreement that was drawn up by my husband's law firm, but in this case, given the friendship that Brian and I shared, I felt that a letter was most appropriate.
Now I'd like to introduce to you what's been stipulated to and admitted as full, Defendant's Exhibit B. Can you see on your screen what is Defendant's Exhibit B? It says at the top, Roberta Quinlan, Business Broker, Broker Agreement.
Yes, I see that.
And is this the type of form that you normally use when you form an agreement with a customer?
This is exactly the form that I use when I do form a partnership or a sales agreement with a potential client. Yes, this was drawn up by my husband's law firm. Correct. Yes.
In addition to witnesses signing that agreement.
Yes.
You did none of that in this case, isn't that true?
No, that would have been inappropriate given the friendship that Brian and I did share.
But you would agree you did not use that form with Mr. Kane?
No, a letter of agreement seemed most appropriate.
And I do want to ask you some questions about this letter of agreement that you've described. You haven't used a letter for a recent deal, isn't that true?
I do not recall in recent memory using a letter of agreement. That is correct. But given the extraordinary relationship Brian and I shared, a letter of agreement seemed most appropriate. Yes.
And the letter of agreement, you were asked questions about it by your counsel, which has been marked as Plaintiff's Exhibit 2. That wasn't the first letter you wrote.
Correct.
In fact, you wrote a letter sooner in time to when you actually formed what you allege to be an agreement between you and Mr. Kane.
Yes, there was a first draft letter, yes.
Okay, and I would like to show you that letter. Can you see the letter that is marked as Defendant's Exhibit C?
Yes.
Okay, and I'd like to represent that this exhibit has been stipulated to and admitted as full.
All right, submitted in full.
And this is the first letter that you wrote.
That is correct. Yes, this is the rough draft.
And you would agree that this letter that I'm showing you right here is different from the letter that you actually mailed out to Mr. Kane. You would agree that they're different letters.
They are different letters, yes.
Okay. Now I'd actually like to introduce to you a demonstrative, which has been stipulated to, and it has the letter that you sent and the letter that you first wrote side by side. I'm going to ask you some questions about that. Here, I'll underline it. Do you see that?
I do.
Okay. In the first letter, you state, Kane Electronics will pay me at an amount to be decided upon a later date.
Correct.
However, here, to the right, you say, Kane Electronics will pay me a fee calculated at between 3 to 5% of the closing value. Do you see that right there?
Yes, and that is one reason why there was a second letter, and the first letter was a rough draft in his den on that Sunday afternoon, whereas the second letter is more specific as to what Brian decided he would like to do, how he would like to proceed with the sale of his company. Yeah. Very well.
No further questions, Your Honor.
All right, thank you. Is there any redirect, Mr. Kasimian?
No, Your Honor.
Very well then. Does the plaintiff have any further witnesses?
We do not, Your Honor.
Okay, very well. So you rest?
Plaintiff rests.
All right. Okay, Ms. Murphy, you may call your witness.
Your Honor, I call my first witness, Mr. Brian Kane, to the stand.
Hello.
Okay. Good afternoon, Mr. Kane. Welcome.
Good afternoon.
All right. We'll have the clerk now swear you in.
Mr. Kane, please raise your right hand.
I do.
Thank you, sir.
All right, you may proceed, Ms. Murphy.
Thank you, Your Honor. Mr. Kane, please state your full name for the record, spelling your last.
My name is Brian Kane with a K, K-A-N-E.
Briefly tell us a little bit about yourself.
Well, I'm a resident of Nita City. I've lived here all my life, and up until recently, I was the owner of Kane Electronics.
And we are here today regarding the company Kane Electronics that you sold to Nita Computer World. Can you briefly describe how you came to form the company?
Well, I graduated from Nita University with a degree in business, and after I graduated, I moved to Boulder, Colorado. I worked for Wellfleet Digital Manufacturing for 3 years. And after 3 years, I decided I wanted to own my own company. So I moved back home, and with the help of some friends and family and the bank, I borrowed some money and I started my own company.
Can you provide more detail about your company?
Well, I sold televisions and electronics at the beginning in one retail outlet, and when the computer industry started, I started selling computers and computer equipment.
And you sold your company. What prompted you to consider selling?
Business was my life. I was the only man. I was the president. I was the sole shareholder. I was the founder.
When did you finally decide to sell?
Well, I started having some pretty serious problems in my marriage. I was spending too much time at work and not enough time with my wife and children.
And what was the first step you took to committing in your mind to sell the company?
The first step, I hired some appraisers to get an idea of what it would be worth.
And did you get a response?
I did. I got estimates from anywhere from $8 to $10 million, which I was quite pleased about.
Did you find a buyer?
I eventually did find a buyer. Yes, I did. Mr. Cliff Fuller.
And how did that come about?
Well, he called me. He's the general counsel at Nita Computer World, and he called me. He told me that Roberta Quinlan had referred him, and I got a phone call. We met, and eventually we formulated a business agreement.
And how do you know Roberta?
She was a friend of mine. I knew her mainly from the golf course.
And you mentioned when you were talking about how Cliff Fuller was a potential buyer representative that Roberta came into play. Did you have discussions with her about selling your company?
I did. I talked about her. I talked about it with her mainly on the golf course. Mainly one day she went, when I really decided in May that I was absolutely going to sell, I made the mistake of telling her that during a round of golf, and it got pretty intense.
And then what happened after you had that conversation with her when you were playing a round of golf?
She wanted to meet after the round of golf. She wanted to keep talking about it. I was trying to get her to just relax and enjoy the day, which I wanted to do. And so I blurted out, why don't you come over tomorrow and we'll talk about this? And she did.
Okay, and you talked to her the next day. Did you have any further discussions with her prior to selling?
No, not after that one day. She sent me a letter saying that that after I formulated the sale to Nita Computer World with Cliff Fuller, she sent me a letter. A week or so later, she sent me an email telling me that I owed her a broker fee. So that was the only communication we had.
And I would actually like to direct your attention to that email you just described.
Okay.
What I'm showing you, and can you see it on the screen?
Ah, yes.
Okay. And this is Defendant's Exhibit A, which has been stipulated to and admitted as full.
Mm-hmm.
Okay. Is this the email correspondence you're referring to?
Yes, it is. That is it. Yes.
Okay. And I'd just like to direct your attention to the first paragraph. Do you see my arrow?
I see that. Yes.
Okay. In which you say, Roberta, I can't believe you think you owned a commission on the NCW deal. We had no agreement, letter or otherwise. Yes, I did receive your June 12th letter, and I immediately had my secretary mail it back to you after I personally marked it, quote, unacceptable, and signed it. Did I read that accurately?
Yes, you did.
No further questions, Your Honor.
Okay, thank you, Ms. Murphy. Mr. Kasimian, do you have cross-examination?
I do, Your Honor. Before you went golfing with Ms. Quinlan on June 11th, you knew she was a business broker, right?
Yes, I knew that.
In fact, you knew her for a number of years before you went golfing with her on June 11th, right?
I did.
And over that time you knew her, you were impressed with her knowledge of business, right?
Yes, I was impressed.
And not just business in general, you were impressed with her knowledge of the electronics business, right?
Yes.
And that was the same business you were in, is that right?
That's correct.
Right, but to my question, you understood and knew when you went golfing with her on June 11th how she earned compensation in her line of work, right?
Yes, I knew that.
Now, when you went golfing on June 11th, who brought up the discussion of selling your business?
I did.
And when you told her about it, did she get all excited and want to talk about it for hours?
Oh, she certainly did. She wanted to go on and on and on about it. Yes.
Did it occur to you while she was, as you say, going on about it, excited about the opportunity to earn a commission on the sale of your business as a broker?
I never agreed to pay her a commission on the sale of my business.
Mr. K, my question isn't whether you agreed. My question is when she went on, as you said, about the potential sale of your business, did it occur to you that she was excited because of the opportunity your discussion presented to her of earning a commission as a broker on the deal?
Yes.
And you told her that's something the two of you could discuss at your house the next day, right?
Yes, I did.
Display to the court what's been marked for identification as Exhibit 11. Just give me one moment. Let me just zoom in so we can see that a little bit better. First, Mr. Kane, just so we all are operating here technologically, do you see an image on your screen?
I do.
Okay, and can you tell us what that image is?
That's a layout of my house.
Okay, so Exhibit 11 for identification purposes is a layout of your house. Is this layout a fair and accurate representation of your house?
Yes, it is.
Now, when you met with Ms. Quinlan on that Sunday that we've been discussing, the day after your golf game, where did you meet her? Where did you meet her?
Right in the front entry of the house.
All right, so let me just zoom in here.
Mm-hmm.
Okay, so I just want to make sure that, did you meet, I'm going to circle the word entry here. And is this area that I've circled depict where you met Ms. Quinlan on that Sunday?
Yes, I came out of the house as she was coming up the walk and we met right there, yes.
Okay. And so you greeted her. After you greeted her, where did you go?
We went into my study.
Did you stop anywhere else before going to your study?
No.
So you went straight from the entry to the study, is that right?
Correct.
Okay, so would it be fair to say that you met where the circle is that says entry, and you took the path down, you took a left, went straight into your study as I've drawn with an arrow on Exhibit 11 marked for identification purposes?
That's correct.
Okay. And you didn't stop in the living room, did you?
No.
And you didn't stop on I'm sorry, you didn't stop on the lanai, did you?
No.
Okay. At this point, Your Honor, with the marked exhibit, I'd like to move Exhibit 11 with the annotations and the testimony that corroborates it into evidence as Plaintiff's Exhibit 4.
No
Sir?
objection.
No objection? All right, then this will be, Plaintiff's Exhibit 4 will be full.
Now we're in your study. We just got oriented there. During that conversation in your office, was Ms. Quinlan trying to get you to agree to make her the broker for the deal involving the sale of your business?
Yes, I would say she was.
In fact, you felt like it was a sales pitch, right?
It certainly did.
And it's your and just so I understand, is it your testimony that you knew that your friend was pitching you to land a deal that could net her between $300,000 and $500,000?
Well, she was very aggressive about that, and she mentioned the broker fee, and she talked about the way that this deal could be structured, and she went on and on. We met for a couple of hours, and then fortunately my wife came in and reminded me that we had a social engagement, so that ended that.
You didn't say to her words to the effect, "There's no way I'd agree to a fee like that," right?
I didn't want to be rude to my friend.
By the time you met with Miss Quinlan on that Sunday, you had tried and gone out to people to see if someone would be interested in buying your business, right?
I put feelers out into the community. Yes, I did.
Did any of those feelers result in the sale of your business?
Not until I got a call from Cliff Fuller, no.
Well, let's hold on. You didn't speak with Mr. Fuller before Miss Quinlan introduced him to you, isn't that right?
Miss Quinlan called Cliff Fuller and said to call me. That is correct.
So sitting here, you don't know, your testimony is you didn't know what she'd do based on that meeting, right?
Correct.
And if you had thought about it, you don't know whether she would have tried to go out and find someone for your business, right?
No, I didn't know what she would do after that particular
Mr.
day.
Kane, do you recall giving a deposition in this case?
Yes.
And during that deposition, do you recall answering questions that I presented to you?
Yes.
And before you answered those questions, do you recall raising your right hand and being sworn by the court reporter or the stenographer to tell the truth?
I do.
And in fact, you took the same oath today that you took before that deposition began, right?
Yes, I did.
I'm going to show you a portion of your deposition. One more, I just share the screen. Hold on. Mr. Kane, do you see what's entitled your deposition summary on the screen?
Yes.
Okay. I'm going to just scroll through this document. So I'm going to draw your attention to the last page, Mr. Kane. Do you recognize the signature on that last page?
That's my signature.
And I'm highlighting that signature. That is your signature, is that correct? Now, you were asked at your deposition the question, what did you think she'd do based on this meeting? Do you see that on page 19, line 14?
Yes, I do.
And your answer was, and please, my question is, did I read this accurately? Well, had I thought about it, I guess I should have known Roberta, as aggressive as she is in business, would try to find someone to buy my business and get the sizable commission for the deal, but I never hired her to do that for me. She took that upon herself without my approval. Do you see that?
I see that.
Did I read that accurately?
Yes, you did.
And who told Mr. Fuller to reach out to you on the potential sale of your business?
Roberta Quinlan.
Do you recall the precise date of that call with Mr. Fuller?
Not the precise date, no, but I believe you're correct. It was late June.
Okay, I'm going to show you what's been marked as Exhibit 3, Plaintiff's Exhibit 3. Just give me a second. Mr. K, do you see an image in front of you on your screen?
Yes, I do.
It's been marked and admitted as Plaintiff's 3. I guess first, Your Honor, it's stipulated, but I want to be clear that I'd like to make sure Exhibit 3 is in evidence in full.
Is there any objection to Exhibit 3, Ms. Murphy?
No, Your Honor.
All right, then Exhibit 3 is full. Thank you.
Mr. Kane, do you recognize what's been marked as Exhibit 3 and admitted?
Yes.
What is it?
It's a little note that I took while I was on the phone.
Do these notes refresh your recollection as to when you had your first call with Mr. Fuller?
I would say June 27th.
So that's a yes, right? Refreshes your recollection, it was June 27th?
That is a yes.
Okay. In fact, this conversation with Mr. Fuller that you had on June 27th, it was promising, was it not?
Very.
In fact, you wrote in your notes, just scrolling down, you wrote, sounds promising, right?
Correct.
And that relates to your conversation with Mr. Fuller, does it not?
Yes, it does.
And Miss Quinlan is the reason this conversation took place, isn't it?
Yes, Miss Quinlan told him to call me, yes.
You refused to pay Miss Quinlan. Well, actually, just turning back, you recall your testimony earlier about marking a letter for Miss Quinlan as unacceptable?
Yes, I do.
Okay. You don't actually have a copy of the letter you sent her, do you?
No.
You ultimately refused to pay Miss Quinlan her commission because you thought she really did nothing to earn the fee, right?
She didn't.
Well, you met with her on June 11th to play golf, right?
Yes.
And you discussed the potential sale of your business with her then, right?
Yes.
And then you met with her on Sunday at your home office, right?
Correct.
You discussed the sale of your business there, right?
Correct.
And you went into details about the potential sale, did you not?
Yes.
You discussed the type of sale, right?
We did.
You discussed the potential sale price, correct?
Did.
You reviewed appraisals with her, correct?
That's correct.
And she advised you that you should net $10 million for your business, did she not?
She did give that figure, yes.
And she spent hours with you between Saturday and Sunday talking to you about this potential sale, did she not?
Well, she spent a couple of hours on Sunday, yes.
Okay, but between Saturday and Sunday, she spent a couple hours with you, correct?
She talked a lot on the golf course on Saturday, yes. I would say yes.
And you sold your company ultimately to Nita Computer World for $10 million as part of a stock exchange, did you not?
That's correct.
No further questions, Your Honor.
Okay, thank you. Is there any redirect, Ms. Murphy?
No, Your Honor.
All right, any further witnesses on behalf of the defendant?
No, Your Honor. That is our first and last.
Okay, very well. All right, then the presentation of the evidence in this matter is complete. I will receive your arguments by brief, and we'll draw this hearing to a close. Thank you both very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
So thank you very much. This was great. And I'm going to put my first question actually to the lawyer, because as somebody who's in the Zoom audience, right, the public, I could actually feel particularly, right, the plaintiff's lawyer was just, I felt like the witness. How, if at all, has transitioning from a live environment in the courtroom to the online environment changed your relationship as a lawyer with the witness, with the judge? What would you say about that?
I would have to say that it's difficult to get that eye contact, or at least know whether the witness can focus in on your eye contact and pay attention, because it's difficult for us to really see what they're seeing versus in court. It's very apparent. I mean, you kind of operate blindly, but if it's your witness, this is something you can practice. I think the challenge is when you're doing a cross-examination, to have that control. You don't have that same control, so you may have to make some type of verbal cues to a witness on cross-examination to make sure they're focused on your attention, because I think easily a witness could be diverting their eyes or distancing themselves from the computer, anything to kind of avoid your presence or force through the computer.
I think it's a great question, because one question I get a lot, we do remote depositions, and as we do remote hearings and potentially examination of, I would call it, let's say, hostile witnesses, right? One of the concerns I've heard, and one that I've had, is when you're in a courtroom, at least I think lawyers tend to think that to the extent to which we can have a good assertive cross-examination where we're controlling the witness, where we're trying to shake them a little bit, when we're trying to get them to give us testimony that we'll find helpful, I think a lot of us think there's no substitute for the in-person examination. What's interesting about this is I think you're right. That may be true, but one of the advantages we get here is, I mean, we are right in their face in a way that I don't know whether a judge would ever let us really do. I mean, we are, depending on how close that monitor is to their face. I mean, if you've got me zoomed in and my face is 14 inches and it's 6 inches from your face. Nothing I'd get away with or even try to do in court. So I've heard it could be a bit of a mixed bag on that. And it's not necessarily that you lose that ability. We wanted to give an example of kind of a somewhat adversarial cross.
Great. I have great answers. Let me turn to the actors and because our actors have actually done this exact case in the live setting, and now you're doing it online. How did it feel to you? Different or not?
Well, it was different for me because of Paul. He's really good at his job, and he's not going to let me get away with anything. I found myself in the past going with different lawyers. I found myself being really easy and nice to lawyers that were obviously visibly nervous, and really kind of, I'll give it back to you if they came in cocky and, aggressive. So I enjoyed this format because I could look right at him, and that was really good. Although I did miss the whole environment of the courtroom. My room that I am in now is small and hot.
Kathleen, what do you think?
Well, I also miss the courtroom. I do think that if you are being cross-examined, you have a little bit more wiggle room. You are not as much under the gun. I do think in this particular situation, your attorney does have an opportunity to form a bond with you, either by rehearsing via Zoom, as well as corresponding with you on through email or texting, and that gives you another level if that's considered appropriate, which I guess at this point it would be if they're trying to prepare you. Our rehearsals, I thought, were very helpful. You just don't know what a real witness will do on Zoom, so you have to be prepared for that.
If it were a real case, would you have your client in your office with you in this type of a proceeding? Obviously, observing social distancing. What's your practice?
I'm just curious of how it would be conveyed to the judge if they're in the same room, because I think your natural inclination would be to look at them this way, but then you're not looking at the screen. But I do think, just physical presence is comforting. So maybe you're in a different room, but you're in the same spot. That I think could be comforting. But I think as far as, because we recognize through this practice, eye contact is extremely important. So the gallery view needs to be at the top. Otherwise, if it's to the right, there's eye contact. But we're focused really on how this conveys to the judge. So eye contact to the judge, I think, or showing the eye contact to the witness through Zoom is important. So I question whether, again, for filming purposes, it's so simple to do in separate rooms where each person has their laptop. So I don't know if it's even worth attempting to mix it up.
I think for the client, it might be more comforting. One thing, technology, if they're not comfortable with technology, that adds another layer of confusion, worry. Whereas if they can be with their attorney, who they probably have chosen, they can be more comfortable, confident, maybe even a little more relaxed.
So judges, let me ask you this same question. In transitioning from the courtroom, the beautiful, beautiful courtrooms, which we all miss, to online hearings, how does that change your relationship at all, if at all, with the lawyers? How do you feel? Do you feel distant? Do you feel closer? How does that affect your experience of a hearing? Maybe start with Judge Smith.
Well, I'll start off. I think it's much more of a tunnel vision kind of experience because the screen is changing from one speaker to the other speaker. So you just see that speaker, or if you have it on gallery view, you see the faces of people, but I tend to keep it on speaker view because I think the gallery view is distracting and it's too much of a thumbnail. I do feel that you just don't have the same kind of feel for the entire environment because in the courtroom, you're watching everything that's going on. You're watching the lawyer and the witness, but you're also watching other counsel and who's in the gallery, and you can see who is having eye contact with whom. And I mean, there could have been objections in this examination, for example, when Mr. Kane got kind of running at the mouth a little bit without a question posed in front of him. I was waiting for somebody to object and move to strike, but that didn't happen. Maybe they didn't want to interrupt the flow. You know, when that happens in the real courtroom, you can look at the lawyer as if to say, okay, are you going to object or not? I mean, speak up. You know, those kinds of little dynamics that take place in the real courtroom aren't happening in this. You know, I think it's effective. We've done enough hearings now of all different sorts that I think we're probably, much more comfortable with the technology, and it's kind of our new reality.
Is when you see lawyers online, arguments or hearings, what do the most effective lawyers do? What are the characteristics that make lawyers most effective when they're appearing in this setting?
Well, one, you have no control over it. It's to follow up on what Judge Smith said, and that has to do with the use of the speaker view versus the gallery view. I find when I set it on speaker view, and it's particularly true in sentencing, so it's been true in attorney arguments, that I am far more engaged with and connected with the person that I'm speaking to than even in the courtroom. They're far away. There's so much, as Judge Smith said, going on. If you know that if you know the person you're speaking to, the judge in this case, has it on speaker view, you're connecting with me completely, and you need to know that. You need to use that to your advantage. If you don't know that, then shortness is more important than ever before, because while we don't have a lot of other things to look at, we are focused, far more focused, I think, than sometimes even in the courtroom. At least my big courtroom, I've got plenty of other stuff to take my attention if the lawyers are rambling. So I think it's really key that far more concise, and sometimes it's hard to keep your intention versus in person. And so I think you need to be more organized in your presentation. You know, I have 3 points. The first point is, et cetera. So I think conciseness is important with lawyers when they're doing telejustice. And I think organization are the two big pieces.
Judge Stern, would you like to weigh in on that?
One of the issues I've seen is that certainly if an attorney is in front of you, they can work off the court's body language as well, which is, let's move on type of thing, even if it's not said. And it's very, very difficult to get that across. The other thing is it's much easier to put a stop to or interrupt to ask a question in court. Sometimes with the way it's set up, it can be difficult to do as well.
And Judge Stern, let me follow up with you, because obviously you're coming from the state court perspective. Does this, what we've seen in the hearing today, does that look like the same experience you would have in state court? Is that are there different skills involved, different equipment?
The biggest difference, I would say, is that one of the Brady Bunch screen on here is our court reporter. So there's actually a record taken, and that can turn into some interruptions sometimes, as we saw, in terms of there were problems with connections themselves. The other big difference is we're still kind of testing it, but at this point at hearings, the clerk is the only one who's controlling the exhibits. So everything is pre-filed, the clerk will put it up there, as opposed to having each attorney have access to control the screen and doing that. Other than that, this seems very, very similar to what we do.
And let me follow up on something that Judge Stern said, which may resonate also with the other judges. Are there aspects of what we've all had to learn going online that you would actually like to see change court practice going forward, even after we're able to return to a live courtroom setting? What would you like to see preserved, if anything?
Well, I don't know if I can. I think in the big picture, what we're going to find is that this is going to change the way we do business in the long run, because we're going to have found that we have this technology which would have taken us many, many years to adopt and adapt to, that we were forced to all become skilled at in a very short time frame, and the efficiencies associated with it are incredible for all of us, I think. So it's I think even after we're done with the pandemic and we return to business as usual, we're probably going to retain aspects of doing routine things using these technologies. So so I guess in kind of the macro view, I'm in favor of taking advantage of that technological shift so that we can be just better at our jobs and more efficient at our jobs. In terms of the actual kind of effect on technique or on style, I don't see anything that's going to really change as a result of doing this online. I would like to make one point about style, though, if I could just digress, because I think it's it's worth talking about. It certainly is true, I think, that the camera exaggerates behaviors that might be a little more subtle in the actual courtroom. And without picking on the lawyers, but they volunteered for this, so I do want to make a little point. The camera really shows your body language and shows your body movements. I think more dramatically. It occurred to me that it's more dramatic than in the courtroom. So when you were both asking your questions, you had your papers down on the table or desk in front of you, and you tended to put your heads down to look at your notes and your script. And the camera really shows that. Whereas when you're in the courtroom, you're at a podium and your eye level is, you're not looking down so much. There's a shorter distance between the eye contact with the witness and the notes. And of course, I don't have anything to do but just watch and listen and think about these things while you're asking all your questions. So that really struck me. So I wanted to make a recommendation that you get one of these little devices that are like little stands that you can prop up and put your papers on, because since the camera can't see everything that's next to you and behind you, you can stick this next to your Caroline's got it. She's got it going. Well, it's true. Caroline didn't look down as much, and that shows you why. You can have teleprompters and nobody would even know it. You can have all your notes with stands, and that will keep your eyes up instead of down.
Well, let me follow up with another question that relates to what Judge Smith has said, which is that obviously you're right that the lawyers are being right on top of you like that, right? It is exaggerated, right? What happens without naming any names, okay? There were points at which it was like, you say this, that. Now, question, right? You would never let a lawyer get that close to a witness, right? In real life. Grounds for objection? Are there new objections that we can make in this online environment? Judge McConnell, what do you think?
I can't imagine chastising a lawyer or sustaining an objection for their physicality over a video. Certainly if they were badgering of some sort, then it would, but yeah, I can't imagine sustaining an objection to something like that. You do have to be careful though, because the truth is that you can either get too intimate or you can get too in your face with the witness, and you may want that. That can either be a good thing, depending on what you're trying to accomplish and who the witness is, or a bad thing. And that is, as I think Judge Smith said, that is exaggerated in this medium. But let me also say, the bottom line is, it's really not a lot different. I mean, you know, there are Zoom classes about how to conduct yourselves during all this. And the truth is that I have found that it's as easy as walking into court and doing what you do. And lawyers should realize that, and lawyers should be comfortable with it. And particularly seasoned lawyers that may not be as technologically advanced should most certainly feel comfortable, because all of their talent and their theatrical abilities in a courtroom and everything that goes with it, they can bring that to this new medium, and they're going to do just fine. It is not that different lawyering than it is in a courtroom, I don't believe.
So Judge Stern, let me turn to you. Do you have any advice that you'd give to a lawyer who's appearing before you for the first time on in a Zoom hearing?
That to practice, okay, to call another attorney in their office, call someone else, know what the buttons do, work through it. Very importantly, make sure you have a good internet connection, whether you're hardwired, and there's all different views. One of the bankruptcy court in Connecticut requires that you use your iPhone or an Android because they feel that that has a better connection to the system. I don't know. And then it's just take a step back. What we're doing here is what we do in the courtroom. I would like to just add to that question you had asked or answer about kind of post-pandemic and what do I see? Because one of the things that I found almost universal acceptance for, and attorneys been saying, why didn't we do it before, is conferences and case management conferences. I now have the ability, especially on complex cases or class actions, to have conferences, once a month, even if it lasts for 10 minutes, to see what's on track, without having attorneys flying in from around the country, without having them all have to come around. And it's really been a wonderful thing. And there's discovery, there's kind of hearings, there's trials, but at least with respect to conferences, I see it as a big positive to allow the court to be able to stay updated and manage the case, even when all this is over.
And actually, speaking to the experience, and I assume that everybody would recommend this as well, one of the great things that's happening, obviously, with this online capability is that court hearings, I don't know if this is true in the state court as well, but I know in the federal court, the public, many more people, right, have access to court hearings because they're posted publicly, right, and people can attend. Is that something that's also happening in the state court?
It is. Part of the order allowing the court system on the state court level to conduct remote hearings is that they need to be accessible to the public. So we've set up a YouTube audio channel for every individual judge with their calendar posted. You can click on, hear the audio only. There's not it's not kept after the hearing, so you can just listen live. But I had one hearing in particular that I had well over 100 members of the public because it involved a large issue of a travel agency that had called in, and they never would have had the opportunity other than driving to the courthouse and waiting for the case. So yes, that is a part of the state system.
Well, this has been an excellent discussion. I'm going to give each of you a chance to give one quick piece of advice to the people who are watching this video about the one thing you would tell them to do to get ready for successfully holding an online argument. Paul.
It's really important to practice. I agree with that recommendation. So we did tested the connections we've had. We actually had a blip or two with the sharing. I am curious that, people can connect different ways. So what you saw today, what we tried to do is we try to cover the gamut, make it more about the techniques of sharing and doing these remote hearings, right? So we've tried to run the spectrum. So on the documents, you saw the use of like Adobe to share, which is what Caroline did. What I did is I connected my iPad and used just a note-taking app within the iPad, installed the exhibits, and that allowed me to highlight and underline and do the same. So it's flexible, and the technology is very flexible, and you don't have to. There was no special software really used for this presentation at all. You can absolutely use very fancy software if you want to, but the point is, part of the demo today was really trying to keep it simple. So hopefully that part shined through. So I think keeping it simple. The other piece of advice is, I've heard people talk about having witnesses annotate documents on Zoom. And I could just tell you my 2 cents is you got to really know your witness. I'd be very hesitant to let an adverse witness control the screen or start inputting information on a document. And the other piece is, and it was Judge McConnell, I think, said it, is it's not that different from what you would do in court. So I appreciate that we're focusing on that, and everyone's style is different. And I think that my direct style was different than my cross style to kind of just highlight different kind of ways people are going to conduct themselves and do the hearings. But I do think that what I've been telling people with depositions is it's not that different, and there's a little bit of anxiety. So I don't think it's that big a deal. And as long as you've got an understanding counsel, which most of the time you do, and understanding courts, it really isn't that big a deal.
Thank you, Paul. Carolyn?
Yes, I also echo on keeping it simple. I limited my software to Zoom, which is not as advanced and doesn't have the easy use of highlighting, but I was able to use it simply through Zoom, which I think attorneys are going to be curious about. Can I just do it all through the software through Zoom? Which you can. Obviously, you can add features. I think another recommendation with preparation, I think one of the barriers, and obviously with the COVID situation, it's a comfort level, but if you can have your witness, if you're preparing, be physically with you to give you some live feedback, maybe have a laptop set up on the other side to see how you're conveyed through the screen or any issues, or in a separate room. I think that's one of the recommendations I have, because although we rehearsed, it was still difficult to really get a sense of what the witness sees through the screen. So I think that's important. And obviously, if you don't have the ability to do it with your witness, practice with another attorney in your office, but almost mimic the situation. Have them on a separate laptop, separate room, or in the same room, just give you some real feedback on how it's conveyed. One of the things I recognized in this issue, and I know obviously one of the concerns probably for several attorneys, is the potential for technological difficulties at internet. And I can tell you, I've practiced this multiple times. Internet wasn't an issue until today. Murphy's Law definitely applies. With Kathleen and cross-examination, it actually paused for a second. And so, there's ways to work around it. You just ask the same question again. Ask them if they heard what you said, because obviously that's a challenge here. It's inevitable. There's going to be technological issues, no matter how many times you practice. Just to be important that there's ways to work around it. You may just have to ask the same question twice, or confirm with the person, did you hear what I said?
Thank you. Great advice. I'm going to ask our two clients/witnesses, what would you tell a lawyer from your perspective as to what works best in this, working with witnesses and clients in this environment? Richard, what do you think?
Well, we tend to focus on a lot of things when in the past programs, like body language. There was one young lawyer who kept his leg was shaking and shaking and shaking behind the podium, and we had to say, your body language. So all we have is this now. So I would say to just concentrate, maybe not be going, okay, and be still. Again, as Carolyn said, the technology, because yesterday I lost my internet and I went, oh my God. And it took 3 hours to get it back. So I thought, if this happens tomorrow, I'm dead in the water. So you need a backup for that, but I think just the facial things. When we do acting classes online, you have to be careful when a student is talking not to go, it's very, so you're right here. So that's all the body language that you have. And before I get closed out, I got to say this program in the past few years has taught me the respect and admiration of your craft and what you guys do. It's amazing what I have learned. So thank you very much for this.
Well, we have greatly appreciated your contributions and yours, Kathleen. Really, without the actors, our program would not be what it is. So thank you so much. And I love you, particularly as Brian. Oh, you're always a good one. Kathleen, you're an amazing Roberta. So what do you think?
Paul wouldn't let me get
I
away.
will parrot what Richard just said about this program. And I am married to a lawyer, but I am very appreciative of everything that this program has taught me with regard to how hard you all work and how much you truly care for your clients and the law and upholding the law. And I will say, for lawyers, try to instill in your client that they need to tell the truth. And if they are telling the truth, the story will always out. It will always be correct. And if you can establish a rapport with your client, they will have confidence in you and comfort in the whole case going forward. And as Caroline said, if it's possible for you to be together, that would be wonderful. Even if it's you on one laptop at one end of the desk or in another room and them in another place, if you've established a relationship with them, they will feel so much comfort and they will be a much better witness knowing that you're there.
Thank you. And Judge Stern, I'm going to give you the first shot at the words of advice.
First of all, one of the things that I've noticed, and even in our state courts, is that different judges have different preferences in terms of what attorneys and others wear when they're in the hearings, whether they require dresses, suit and ties. And I've unfortunately been presided over hearings where I've got, 4 people in 3-piece suits and dresses and one person who's wearing something different. It's very easy to find out what that is, and it takes a lot of the agita out. The other thing, again, can be embarrassing is, remember, we're not only seeing your face, but we're generally seeing your desk and what's behind it. So just be aware of when you're on full screen view what we're seeing. I had a hearing this morning, and I jokingly said to the attorney, I guess you're really busy, because it looked like Raiders of the Lost Ark with everything piled up to the ceiling. So it's something to just something to keep in mind, that if you think about that, then you don't have to worry about it when you're in the middle of the hearing.
Judge McConnell, how about you?
I don't have a lot to add to what Judge Stern said. I think he actually summarized it well. I would emphasize, I call it, get on Zoom and play around with it. Call a friend, call a neighbor, call your mother, and try the different aspects. It's very user-friendly, but you have to explore a little bit to find out how do you change your background, to find out you can, people that don't have video on, you can get rid of their screens, how to go to gallery view versus singular view. So just go on and play around it. People should relax. That I can say for the federal court and for all of my time spent in the state court, judges are reasonable, they're understanding. If something goes wrong, please don't not participate because you fear something can go wrong. Now, we want you to be prepared like we always do, and we want you to understand the technology, but folks should not pass up the opportunity to appear before the court, particularly with the potential for bench trials, which I encourage, because while harder to do a jury trial during the pandemic, though we'll figure that out, right now folks can get bench trials, and the ease of doing it should encourage every lawyer to consider whether they can ask for a bench trial, at least in the federal court, and not be afraid of the technology. We, just as phones go off in courtrooms sometimes, sometimes you talk and your mute button's on. I mean, it's really not a whole lot different. So my advice to people is relax, be the good lawyer that you are, represent your client, do justice, and get used to this new world order.
Thank you, Judge McConnell. And Judge Smith, as the founder of the Litigation Academy, you get the last word.
All right. Well, who would have thought we'd be doing a program on how to try a case on Zoom when we started all this? It's crazy. I would just emphasize a couple of points. One is, I think this teaches us how much we can learn from lawyers and how much we can learn from younger lawyers, because what Paul and Caroline did with the way that they marshaled the technology and demonstrated so many of the things that can be done without being super sophisticated, using basic tools. It's an education for us, for the judges, because I didn't know you could do some of these things that they did and the way they did them, and they chose different ways to do them. So we're really going to be kind of learning with the lawyers as we go through this. And I think that this is an interesting dynamic generationally, because one thing I've noticed in conducting hearings, that some of the lawyers who are the most uncomfortable with the technology that we're using are the most seasoned lawyers and the ones who are most comfortable in the courtroom. It's clearly taken them out of their comfort zone, and I've seen some really awkward moments in arguments with lawyers who are very, very seasoned lawyers, and I can just tell it's because they just don't like the fact that they're in this environment. They really want to be in the courtroom, and that's where they feel most comfortable. And so now we're seeing the flip side of that. I think Paul and Caroline, who are comfortable with technology, and generationally they're more native to it, and they seem very comfortable with this environment. And the older generation is going to have to adapt, and they're going to teach us. And so that's been really terrific. And they also demonstrated, we always talk about the value of preparation, and you saw that today. They were so prepared, they had practiced, and they had redundancies set up so that if things didn't go right, they knew how to respond to that. I thought that was really terrific. I think they've shown us how this can be done, and we can keep making progress while we're going through the pandemic. So I want to thank all of you for participating, particularly Paul and Caroline, for all the work that you put in to do this demonstration.
Thank you.
Thank you all.